So let's see, I have, my time says 3:03. So I said we we're going to begin at 3:03. We have 7 participants out of, I think, about 10 who have registered. So for those of you who are punctual and so on, we're going to get going with you right now. So my name is Rich Shapiro. On the bottom of my screen, to the right of my bottom, is Megan Conroy. Megan and I are the attorneys in the Estate Planning and Elder Law Department here at Bluestein, Shapiro, Rich, and Barone in Goshen. I assume most of the people on the call are local, maybe not all. And our objective today is to do a little teaching, give you some education in estate planning, and try to answer any questions you have. And like I said, if you do have a question, feel free to post it in the Q&A or chat, and we'll get to it in due course. We're going to cover a lot of material today. It'll run a little bit after 5, probably around 5:15 we'll be fully complete. And we do at the end ask you to complete the evaluation form that hopefully you were able to receive in an email along with the PowerPoint presentation. If you didn't get that, we can send that over to you. So the first couple slides after the cover slide, I'm going to move ahead here, hopefully. There's just a slide with some of my credentials and achievements over the years. I'm an old guy, so I have a few that I've gotten over the years. And Megan has her own achievements. She's much younger, so she is catching up to me very quickly. But we work very well together in our department. We have a wonderful support staff. 3 folks who serve different functions in our practice. And next week we're going to be rejoined by another attorney who started out with us right when the pandemic started. And now that we're moving back into full operational mode, we're going to bring her back on, and we're happy to do that. So let's get to the substance finally. One of the first things people have to recognize is what we call a surprising truth, and that is that most estate plans don't work. When we say that they don't work, it doesn't mean that any legal documents associated with the estate plan are ineffective or inadequate legally. What it means is that essentially what the client's planning objectives, had they been properly educated about what their options are, have not been achieved. And the reason is because people don't know what they don't know. And so if they're not working with someone who really is adept at dealing with these issues, and it's not just document drafting, it's equally important, as we'll discuss during the workshop, it's equally important to deal with the asset ownership, the form of ownership, what we call title. If those things don't mesh, the plans will not work. And a very simple example would be most married couples own assets in one of 2 ways. They either own accounts jointly, whether it's bank accounts or stock or investment accounts, or one spouse is the owner and the other is a beneficiary on things such as life insurance and IRAs and the like. So all those assets, essentially, upon the death of one spouse, by operation of law, pass to the surviving spouse, which on its face sounds like a very appealing scenario. There's no waiting, there's no lawyers involved, none of those kind of things. But when one spouse dies, the other is still living, of course, there are some risks that can be facing the surviving spouse. One is, we call it remarriage risk. If that spouse remarries, let's assume the husband dies first, as we always do in our practice. That's our default death in a married couple scenario. So husband dies first, wife survives, everything by operation of law passes to the surviving spouse. Now the husband's up on his cloud, hopefully nowhere else at that point. He's looking down and sees his wife is getting romanced and wined and dined, assuming restaurants are open at that point. And she decides to marry this new guy. She owns all the assets. The husband on the cloud has no control over what she does or doesn't do. And if she doesn't do estate planning in a proper way, some or even all of those assets can go to the new spouse and his family. Then the other scenario that sort of explains this whole most estate plans don't work concept is the idea the wife is the survivor, never remarries, okay? So let's take that scenario. However, she gets older. And what happens to people get older? They become more susceptible to needing long-term care, whether it's in your home or nursing home or assisted living or any of those places. She now owns all the assets in her name because they had everything passed by operation of law to her. There's no protection for those assets from a spend down should she need long-term care in a facility or at home. Nursing homes, for those who are aware in our area, run on a low level at $12,000 per month. It doesn't take long, a couple years, for your standard middle class estate to be wiped out without proper planning. So those are just two examples. We're going to cover more throughout the workshop that sort of summarize why, in our experience, estate plans by and large do not work.
So when thinking about estate planning, we really want to be thinking about maintaining control of our property, right? So this stuff is your assets that you've accumulated over the course of your lifetime. And estate planning isn't just after death planning or death planning in and of itself. Estate planning is really you having a plan in place that dictates who controls your assets at different phases and where those assets go at each of these different phases. So we want to look at the control of the property during your lifetime. Maybe you're alive and well, so you're going to be the person in control managing those assets, right? After you or a spouse or a loved one becomes incapacitated, what's going to happen to the assets? If you lose capacity, who do you trust enough that they can manage your assets while you can't? And then after you've passed away, who's going to be your trusted person again to control those assets and make sure that they are being distributed in accordance with your plan? So we really want to focus on that control of property and allowing you to maintain the control for as long as possible. And another important factor for estate planning is, like Rich said, it's not just about the documents. We together can put together beautiful, nicely constructed documents. Let's say it's a trust, has all of the bells and whistles, the best language in the world, but if your assets are not titled in accordance with that beautiful trust instrument, then that trust is not going to work. And all of the mechanisms that you used in the trust to control the property will not work because your assets are not titled in accordance with that trust. So we're going to talk a lot about title now for the first part of this webinar. So what we like to say is that the magic rule is that title will always equal a particular result. And we're going to look at the different kinds of title and what result will happen under those different kinds of title. So there are three ways that you can own property at the time of your death. We're going to look at them. The first one is going to be individual ownership. That is where there's just one owner on a particular asset, and that can be bank accounts, real property, retirement, so on. Jointly titled assets, and this is where there are two or more owners listed on an asset. You're going to see this again with many kinds: real estate, bank accounts, investment. You will not see that with retirement accounts, and we'll talk about that more. And then we're going to talk about title by contract. And this is ownership pursuant to a set of instructions. And that sounds a little funny, but you'll find out you're actually very familiar with this. So the first one we'll take a look at is that individual ownership. So let's say for the purposes of individual ownership, we're going to have a bank account at Orange Bank and Trust. Let's say it's a checking account in the name of Megan Conroy. So it's my checking account. So if a person, such as myself, owns an interest in property in my own name, and I lose capacity or I pass away, someone else has to be granted authority to act on my behalf. No one else has that legal authority to control my account, that Megan Conroy checking account, if I were to become incapacitated or I pass away. So what happens, right? We're going to take a look at incapacity, and we're going to take a look after death. If I were to become incapacitated and I've done no other planning, I just have that checking account in my own name, and then I become incapacitated, my family or my loved ones would have to pursue something called an Article 81 Guardianship Proceeding in order for the court to give them authority to manage that property for me. So without asking the court permission and without getting that authority from the court, No one else can manage that account or make sure my bills are being paid, so on or so forth. The guardianship proceeding is really something that you would want to avoid. It is very costly. There are no fewer than 4 attorneys appointed in any single guardianship proceeding. And that's because a lot of people have to have their interests represented, including myself, an incapacitated person in this example. So we have 4 attorneys being appointed on this, each of them being paid, right? Not a cheap process. It's also very invasive. So the court really has to delve in and make sure that I don't have capacity to be able to manage my own assets before they give that authority away to someone else. So it's an intrusive process. It can be time consuming, especially if it's contested. If I have multiple family members who all think they should be given the authority and they start fighting, could be really problematic. So a guardianship proceeding is something that is sometimes necessary when there is no other planning done. But with very little bit of planning, you can avoid the guardianship proceeding. And that's something, like I said, you don't want to have to put your family through. But that's what would happen for an individually owned asset. If I became incapacitated and did nothing else, my family would need to go through guardianship.
Right, just to elaborate on the point, the reason in Megan's example she would need an attorney is because the guardianship proceeding is designed to remove some or all of her individual liberty, essentially, to handle her own affairs, which is a very fundamental right that a person has. So the court has to be convinced by clear and convincing evidence that she cannot manage certain affairs that are being alleged by the person seeking guardianship over her. So there's a lot involved, and because a liberty interest is at stake, she is entitled to legal counsel if she cannot choose her own.
Right. So now let's say I have that bank account and I pass away. Whether I have a will or not, because I owned that account individually in just my own name, before anyone can be given the authority to distribute that asset, it has to go through a court proceeding. If I have a will, that proceeding is normally called a probate proceeding, where the will would be submitted to the court would review it, accept it, very likely appoint the person I've designated to serve as my executor, and then that will gives the instruction to the court and to the executor how I would have wanted those assets to be distributed now that I'm gone. If I don't have a will, that proceeding is called an administration. And so one of my loved ones, friends, or family members can petition the court to be appointed to have the authority to take that individually owned asset and distribute it. Now, because I don't have a will, which is my instructions to the world, that asset would actually be distributed according to state statute. So if I don't leave a set of instructions, each state has a statute for how assets should pass when I have not left a will behind. So those assets will go according to state statute. But either way, the court is getting involved. And so these proceedings, just by the nature of the court getting involved, could potentially take a little bit longer than if we did some planning in such a way that the court did not need to be involved, such as trust planning, for instance. So it could take a little bit longer, and that's just because the court docket, you never really know how many files they have waiting, right? How many matters are pending before that court. The courts recently, with everything happening with the pandemic, the courts were shut down for a time, so things really stalled, and that was something that we could not have anticipated. And so now a lot of those matters are picking back up again, but it's been a good 3 or 4 months that no movement has happened on those matters. And those were the ones that were already submitted to the court. Now you have a lot of people have been passed away from the pandemic, so more matters are piling up. So it really could take a very long time, depending on what the court situation is and how many things they have waiting. There's sometimes additional costs associated with going through the court, such as a probate or an administration, and that's usually because there are also court filing fees. So it could be a small fee, could be large, depending on the size of the estate. But when that petition is filed with the court, there is typically a filing fee that is due in addition to the attorney's fees. Now, with any kind of administration, even ones that don't involve a court, there usually is a good reason for an attorney to get involved. even if it's just to help the fiduciary, being the executor or the trustee or just the loved ones, help them and just give them a little bit of instruction on how to go ahead and administer the estate. So the attorney's fees will very likely be there, but the court costs may be additional. And then of course, if the attorneys have to go to court, they'll spend a little more time and those fees may be increased as well.
Right.
And then go ahead.
I was going to say, and the slide is now slightly out of date because they are starting to proceed with our probates, but for a good 2.5 to 3 months, there was no action in the courts, and that was just gumming up the work. So the good news is they are starting to move again, which is useful.
And then the last big thing was just the privacy. So associated with any kind of court matter, those matters become public record. And so as things do begin to open up, if you want to wear your masks and go down to court calendar, once they let people back inside, you can actually see the court calendar and the matters before the different surrogates courts or wherever you want to go. And you can see what the families are maybe disputing over or what kind of assets are passing through the estate. So it becomes public record, but importantly, along with it just being public record open to the world, anyone who believes that they are entitled to something from the estate, maybe a creditor that's owed some money or a family member that feels like maybe they should have gotten more than they were given under the will, those people have the opportunity to also appear and they can ask for the amount that they believe is due. And then depending on what proof they are bringing, the court may award it if they are truly due that amount. So that's kind of sticky part with public record. So if people are concerned about privacy, maybe probate avoidance is something that they would be interested in.
And taking that a step further, when a probate is filed, and let's say you have 3 children, Tom, Dick, and Harry, and you decide to leave everything to Tom and Dick and nothing to Harry, because he would be what's called an intestate distributee, meaning he would receive 1/3 of your estate if you died without a will, he has a right to go into court and file a petition or file objections. And he's in fact going to be invited by getting a notice of probate that he can file objections to the will. If there is no probate and this is assets going into a trust primarily, he wouldn't get that notification. And not that he couldn't sue against a trust, it's a lot more effort for him and more difficult. So as Megan said, especially if you're looking to disinherit someone, probate avoidance is usually the way to go.
So now we'll look at the next kind of title, and this is joint tenancy. And when we're talking about joint ownership, we're usually talking about joint with rights of survivorship. And that rights of survivorship just means that when 2 or more people own a particular asset as joint owners with the rights of survivorship, when one owner passes away, the surviving owner or owners automatically owns the asset. So it's like the last man standing, and it's by operation of law. So in this instance, no court is going to get involved to say, okay, you surviving owner or owners, you now own this asset. It just happens naturally by operation of law, no court involvement. And that is one reason where people think that maybe joint ownership is going to be a solution to some of those sticky probate items that we just talked about. But we're going to get into some of the weaknesses of joint tenancy as well. So you see with the rights of survivorship there, and as I mentioned, sometimes considered a solution, and sometimes it is. It works for a matter of convenience, but oftentimes there's a better solution than simply relying on joint ownership. And you can see joint ownership used on bank accounts, such as your checking, savings, investment accounts, stocks, bonds, and real estate. You will not see joint ownership on retirement assets, IRAs and 401ks. Those are going to be owned by only one individual at a time.
Clicked. There it goes.
So like I said, the ownership will pass to the surviving owners automatically, which means there's no court involvement, but there are some downsides to using joint ownership as the only planning tool in your estate plan. And I think we get to take a look at some of those. So some of the pitfalls, the first is that no single owner can direct the final disposition of their share of property because the title passes automatically to the surviving owners. So this means if I, instead of owning that checking account in my own name, let's say I own it with my mom, and then I do a will, and that will says I want all of my assets. I have a younger brother. I want all of my assets to pass to my younger brother. When I pass away, my individual owned assets will pass according to the terms of my will. But that jointly owned bank account, because I own it joint with my mom, it will not go through the will to my brother. It will pass automatically to my mom, even though that wasn't really my intent. So I could not dictate that final disposition of the asset because it was owned jointly. It just automatically goes to the surviving owner. Joint ownership does not avoid the need for an Article 81 guardianship proceeding if any of the owners become incapacitated. So sometimes people may think that the solution to a way to avoid the guardianship would be using joint title on a particular asset. But you'll see in instances like with real property, if you have two or more owners on a piece of real estate and one owner becomes incapacitated, but the other owners would like to sell that real estate, let's say, the owners who have capacity cannot simply appear at the closing and sign for the incapacitated owner. Unfortunately, it's going to be more likely that a guardianship proceeding would still need to be had to give someone the authority to sign on the behalf of the incapacitated owner at that closing. So it doesn't eliminate or avoid the need for that guardianship proceeding. Adding a non-spouse as an owner may result in gift tax implications. We're going to talk more about gift tax and why they're not usually too much of a worry for most people, but it's something to be aware of. What are the gift tax implications by adding on a sibling or adult child to a bank account? Are there any? So something to consider. Adding another owner renders the assets available to the creditors of any one of the account owners. So if you have 3 account owners on a bank account and one is getting divorced and the other has a creditor issue, there's the possibility that that account could be frozen and subject to the divorce proceeding or subject to the creditors. So very risky business. You're opening that account up to additional liability. And we're going to see a little more of that in the case study in just a moment. There is no Medicaid protection for jointly titled assets. So sometimes Rich and I will get a phone call that will say, it'll be an adult child on the phone. Mom or dad is probably going to be needing some long-term care sometime soon. Maybe they're about to enter a nursing home. And we're always asking, well, what are the assets? And they'll run through the assets. And then at the end, they'll say, and oh yeah, there's this money market account with $100,000 in it, but mom added me as a joint owner to that account 10 years ago. So we're past the 5-year look back. That account is exempt for Medicaid, right? And our answer is no, that's not right. Because mom or dad's name is still on the account, it will be includable in their resources when they're applying for Medicaid. And so it is not protected. It's not exempt just by virtue of their name remaining on the account. We're going to talk a lot more about Medicaid in the second half of the presentation. Joint ownership often conflicts with the desires of the original owner. So again, this is kind of thinking about maybe I wanted that bank account to go to my brother through my will or through other means, but because my mom was on that bank account, it actually went to her and conflicted with my desire. We're going to see another example in the case study. And any owner on the account has full access to 100% of the account assets at any time. So while you're very likely adding a joint owner to your bank account, and that person is a person that you trust, it is possible that that person can empty out the account and the bank tellers or the representative is not going to stop them or ask them, where are these funds going? Because they are an owner on the bank account. So there's really not going to be much questioning or oversight on that. They are permitted to withdraw as much or all of the assets from that joint account if they want to.
So I'm going to take us on a little journey through a case study right now. And this sort of summarizes all the points Megan's been making in the last couple minutes about joint tenancy and why on the surface it seems so appealing, but in practice it can cause really bad results. So here we have a case study. We have a woman, Esther Jones, who's 82, lives locally here in Walden and is fairly newly widowed. She has 2 daughters, Sarah, who lives nearby down the street in Walden, and her daughter, Kelly, who lives in Texas. Esther had a stroke 2 years ago, uses a walker today. Sarah, a few important facts about her. She's physically separated from her husband, but is not legally divorced or even legally separated, which is an important distinction. Sarah provides general assistance for her mother with all the daily things that mom needs, whether it's shopping, going to doctor's appointments, and all the kinds of things that we see every day with adult children assisting an elderly parent. So what does Esther own? She has her home that was jointly titled with Frank, but now that you're experts in this area, you know upon Frank's death, she's the sole owner, and the house is worth about $250,000. And the other assets that she owns are at the bank, checking accounts, savings accounts, some CDs, another $250,000. And again, because they were owned jointly with Frank, now by operation of law, she's the sole owner. Nice and easy, no probate, nothing. Esther owns $500,000. Her will that she executed in 1992 provided that upon her death, everything would go equally between Sarah and Kelly. And if you asked Esther that today, how do you want your assets divided? I want my daughters to get them. And as often is the case, both Kelly and Sarah are named as co-executors of Esther's will. So one fateful and snowy day, Esther and Sarah make their regular trip to the bank. Again, it's hard to think of snow out there with days like this, but we'll get there eventually. Not too soon, I suppose, we hope. The teller, who doesn't know anything about Esther's family situation or her existing estate plan, sees that Esther's struggling to get around with the difficult weather conditions and her general infirmity. So the teller makes what turns out to be a rather fateful suggestion. Mrs. Jones, why don't you just add Sarah on your bank accounts? That way she can handle all your banking so you can rest easy, you don't have to come in, take all the worry off your mind. What could be easier than that? So that sounds like a great idea to Esther and Sarah. So without giving any thought to what that really means legally, because I don't think there is anything legally about that, Sarah is added as a joint account owner on Esther's bank accounts, and they sign all the paperwork. Here's where the problems begin. No sooner is Sarah added on the account, but that her husband says, I've had enough of you. I'm filing for divorce. So during the course of the divorce proceeding, there are depositions and what is known as discovery, where each spouse is entitled to learn the assets of the other spouse. So during discovery, his attorney learns that Sarah is now an owner of $250,000 worth of bank accounts. And as Megan mentioned during her discussion of the joint tenancy, Sarah has full legal right to all $250,000 of those assets. So his attorney dutifully files a restraining notice on those accounts, meaning Esther can no longer get the money. So what does she have to do? Esther has to hire her own lawyer, go to court, have the accounts unfrozen under the basis that the accounts were really her money, was really her money and not Sarah's as well. Well, Esther's problems, unfortunately, are not over, because no sooner are those accounts unfrozen, but now she finds out the accounts have been refrozen. Not by the attorney's, the husband's attorney or son-in-law's attorney, but rather, as it notes here, she has liked to play the slots and the tables when the casino sadly was open, and the casino had obtained a significant judgment against her, against that is Sarah, that is. So when the casino went to enforce their judgment, they were able to file a restraining notice and freeze all of the bank accounts that Sarah had an ownership interest in, which of course included the ones that she owns with Esther. So Esther again has to go to court to unfreeze those accounts. Now, in the real world, you would hope Esther would have taken Sarah off the accounts after the first time it was frozen, but this is a hypothetical, you understand. So Esther this time does have to go back to get her accounts unfrozen for the same reason that she did the first time. A lot of time, aggravation, and of course, legal expense. 6 months later, Esther's worn out by this whole state of affairs. She has a heart attack, passes away sadly. Kelly, of course, comes up from Texas for the funeral. She gives Esther's attorney, Sally Smith, a call to discuss the will, often is the case, We get calls all the time, even sometimes the same day of a person's death, which is a little surprising, but it happens. So Sally, in discussing with Kelly, confirms that under the terms of the will, the assets are to be divided equally between Kelly and Sarah. Now, of course, when we say the assets, we're only talking about what assets? The probate assets. You've learned that already. And as we've seen, the probate assets are not what Kelly expects them to be. Kelly learns, once she digs deeper into this, that the bank accounts that she thought she was going to share in were owned, in fact, jointly between Esther and Sarah, and therefore now Sarah is the sole legal owner of those accounts. And because of that, as you are now well versed in, the will controls none of those bank accounts. Kelly, of course, says, Sarah, what the heck is going on? Sarah says, well, you know, Kelly, Mom really wanted me to have all those assets, all those bank accounts, because you were living it up in Texas all these years, and I was working my tail off helping Mom get by. Now, that may be, in fact, true, but that's, as you and I and all of us on this webinar know, is not really what Esther wanted. But the only person who would know that is who? Well, it's Esther. And she's no longer around to tell us what she really intended. So Kelly, as will be the case in these circumstances, hires her own lawyer to bring action against Sarah to try to have those joint account ownerships invalidated under the court, under law in the surrogate's court. And of course, Sarah and Kelly's relationship is now irrevocably broken. Now, as a real world scenario, it's going to be very hard for Kelly to have that joint ownership undone, because without evidence that either her mom didn't know what she was doing or didn't have the capacity to do it, or was unduly influenced by Sarah to put Sarah on the accounts, none of which appears to be the case based on our facts, Kelly is not going to prevail. And that, again, Esther looking down from her cloud will not be happy about this result. Not only that Kelly didn't get what Esther wanted her to, but the fact is her daughters, who had a decent relationship at one time, no longer do. We see this unfortunately happen all too often in our real practice. So before we move ahead to the power of attorney, just want to reiterate to folks that if you do have questions or comments, feel free to post them in either the chat or the Q&A feature. We are here for that purpose, as well as to just blather at you and hopefully teach you some things. So we're going to move ahead to the power of attorney. Megan, you can go with that.
So a lot of the issues that we just saw in that case study, they're coming from that suggestion, right? To add the daughter as a joint owner on the bank account, which opened up that account to a lot of liability. And then ultimately that account did not pass in the way that Esther would have wanted. A better tool that could have been used, instead of adding the daughter on as the joint owner, leave her off of that bank account and leave that bank account individual in Esther's name alone. And instead, Esther could have executed a power of attorney. So what a power of attorney would do would allow Esther to appoint an agent or multiple agents if she wants, to have the authority to assist her with her bank accounts. So make sure that the bills are paid or take a trip to the bank without Esther, but without making those agents a joint owner on the account. So it wouldn't have opened up all of the liability that we just reviewed. So Esther could have named both daughters as agents. She could require them to act jointly, or she could give them the authority to act independently, which sounds like that might be the more practical approach, considering Kelly lived in Texas. So she could have named them as her agents under the power of attorney. They would have had authority to manage that bank account for her and any other assets that she might have, but it would not have added Sarah to the bank account, and we could have avoided a lot of those problems. So we like to think that a power of attorney is an incredibly important document, and it offers a lot of value. It's absolutely essential for every person to have a power of attorney, but it is very important when it comes to long-term care planning or nursing home planning, anywhere where the assets really may need to be maneuvered for protection, but maybe the owner doesn't have capacity or the ability to do that strategic moving on their own. They're going to rely on their loved ones for that. So a power of attorney is a very important document, but it also has some weaknesses. So power of attorney is not a standalone kind of solve-all solution to everything. Some of the weaknesses is that a power of attorney really only gives a list of powers and authorities to the agent, but it really doesn't give them any kind of instruction. So Esther can't customize that document to tell Sarah and Kelly how she wants her assets managed. It just says, here, you can manage these assets. Execution of a power of attorney does not take away the principal's authority to act on their own behalf. And that might seem counterintuitive, but as a person ages, maybe they start to suffer from any kind of diminished capacity and make poor financial decisions. Maybe they're susceptible to the number of scams that are out there, right? So if they are starting to lose capacity, the power of attorney doesn't take away their power to manage their assets. And what that could end up meaning is that they sort of squander their assets, or they're managing them improperly at some point down the road. And then also another sort of problematic thing about a power of attorney is that financial institutions sometimes will give a hard time before they are willing to accept the power of attorney. The banks or other financial institutions, they're very concerned about the liability that a power of attorney may open them up to, even though in reality, there really isn't any liability. So as long as they are following the power of attorney, right? They're not just letting any person manage these assets. It has to be the agent designated and in the way that's designated under the power of attorney. But otherwise, there's not much liability, but the banks will still give some pushback. So the process is typically that they'll request an original power of attorney. They'll view it. They'll give the original back to the principal or the agent, but they'll make a note that they've viewed the original and that they've made a copy. Then the copy goes to their legal department for review, and that can take any duration of time depending on how busy their legal department is. And then if the legal department has questions, they'll ask the questions, and it has to get filtered back to the principal or the agent. After a number of times of going back and forth, hopefully the legal department will accept the power of attorney, and then the agent can begin acting. But if it's something that really needed to happen fast, the power of attorney can create this sort of time barrier, this hurdle, because it can take a long time, a number of weeks, I would say, before it's actually accepted by the institution. Usually, though, the institutions are good and it only takes a day or so.
One important factor, too, is never, if you have an original power, never give your only original to anyone, whether it's the bank or anyone else, because there are two things you can do if they want an original. You can get a certified copy, both at the county clerks. You can file the original and get certified copies, or even simpler, in New York, all attorneys are authorized to certify copies of documents they prepared. I have a little certification stamps, and I sign those. That is acceptable as a certified copy as well. A lot of people don't know that. So that's where we go on that. Let's move ahead. If I can move my thing here, it's getting stuck. There we go. So a general durable power of attorney is essential to any estate plan. We do one in every case, but is not alone, as Megan said, sufficient. There are deficiencies, so we have other vehicles that are going to be used to overcome the deficiencies of a power of attorney. So the third type of title is contractual title. And we call it more euphemistically pursuant to a set of instructions. Contracts are supposed to explain things for average person to understand. Of course, you can read some dense insurance contract, and even us attorneys struggle with those at times. But hopefully most contracts are going to be readily understandable. So what are the types of contracts? What is important about contracts in the context of estate planning? Title by contract means at a person's death, the control over the assets, of how assets will pass, are governed by the contractual instrument. So what are some of the types of titles of contractual ownership? Well, bank accounts can have a pay on death or in trust for designation. So as Megan said, in Mrs. Jones's case, she could have given power of attorney to Sarah to act. And if she wanted to avoid probate, she could have done pay on death designation to both Kelly and Sarah, which would have divided the assets equally. That would have been a much better result than what we ended up with. Other types of contractual ownership, we have our life insurance contracts, annuity contracts, and very commonly your retirement accounts. IRAs, 401ks, 403bs, and the like. So the other contractual form of ownership are living trust agreements, revocable and irrevocable, and we'll get to the types and varieties in just a few moments. So all these kinds of contractual ownerships have significant legal implications and benefits to the parties involved. So with our trusts, the living trust can be created both as a revocable or individually as a revocable or irrevocable. And which type of trust is better depends on the purpose of the trust and the circumstances of the person creating the trust. And that's where people like Megan and I would review with our clients what is the best structure. Some people have only revocable trust, some will have irrevocable, some will have a combination of all of those, or both of those. So revocable trusts, as the name indicates, allows for changes or amendments freely to those instruments. And the assets in the revocable trust are still part or included in your estate for estate tax purposes, which in the old days, I'm talking 20 years ago when we had a $1 million estate tax exemption, could often be problematic. In today's world, most of the time, the vast majority of the time, we want assets to be included in a person's estate for capital gains purposes that we'll get to a little bit later. Your standard irrevocable trust, as the name implies, is irrevocable and cannot be changed or amended, with a big caveat. New York law and Pennsylvania law and virtually every state we know of has exceptions in the law that allows for even an irrevocable trust to be modified, and typically with the consent of the beneficiaries. Because who would be harmed by a change to a trust would be the beneficiaries. If they consent, and again, who are the beneficiaries of these trusts? Typically your children. If they say, yeah, we consent to the amendment or termination, the law says we don't care, you can do it. We'll get to more into that when we talk about Medicaid trusts. Typically, but not always, these trusts are drafted to have the assets includable in your taxable estate for the same reason a revocable trust assets are includable in your taxable estate, primarily for capital gains tax benefits. And the one big difference for a revocable trust to an irrevocable trust is only irrevocable trusts can be protected from a Medicaid spend down and will be protected within the context of the 5-year look back period that we'll discuss when we get to the Medicaid slides. So while there are multiple forms of living trusts, which are again trusts created within the trust maker's lifetime, the revocable or irrevocable trust, sometimes you'll see the terminology inter vivos trust on a fancy one, which is really just another name for saying living trust. So inter vivos simply means within life in Latin. There are also trusts created as part of a will or within the context of a living trust that only become effective at the time of a person's death. So many people even have rudimentary wills that they got when their kids were children. Almost uniformly, those trusts will have, those wills, I should say, will have trust provisions. And the standard provision will say, if any of my children or any of my beneficiaries are under the age of 18 or 21 or 25, then their inheritance is held in a trust with my sister Carolyn as the trustee until that beneficiary turns 21, at which time they can be distributed to them, the assets. That is a trust, and it is a testamentary trust created under a last will and testament. Virtually all of our trust agreements or wills contain trust for the reasons that we'll get to when we talk about the trust protections. So the next slide here shows a sort of basic diagram of how a trust would operate. This happens to be a revocable trust. We'll show a slide later with the irrevocable Medicaid trust. And those are the two most common that we use. There are always little varieties of these. We'll talk about the retirement trust as well. There are charitable trusts. There are trusts specifically designed for estate tax planning. Those are more esoteric that we won't deal with so much today. But a revocable trust, think of this box as a chest of drawers. you open your chest and you dump stuff in. So you're going to end up putting your assets into this trust, okay? And while you're alive and well, there really isn't too much drama, other than the fact that my account at the bank says the Richard J. Shapiro Living Trust. I have full access to it. I am the trustee. I have full control. Nothing really very unique or spectacular. So we like to say during your lifetime or your alive and well phase, it doesn't really feel anything like a trust would typically feel. But what happens if you become disabled, or the more common way we think about this is incapacitated? You can no longer serve as trustee because you don't have the capacity to do so. But unless you recognize that has happened to you, which of course is not always the case, you may be merrily along and getting scammed, as Megan was talking about, and ripped off. I mean, I had a woman a couple years ago that was ripped off to the tune of $157,000 before we were able to get it stopped in a guardianship proceeding. But in this context, that should never be necessary, because in our living trust agreement, it'll say if I become incapacitated, and that determination will be made by my disability panel. So who's going to be on my disability panel? Well, it's going to be my wife and my adult children, if I have any. Right now, I think it's my sister-in-law and my father, because at the time I set it up initially, my children were not old enough. My daughter is now. She'll be 25 in a few weeks. So I'm probably going to let her step into the disability panel when I amend my document. But assuming whoever that panel is, if they all say, I've lost my marbles, I may be completely paranoid, completely unrealistic, and some of the people on the webinar today may have dealt with that kind of case within their own family. And I may kick and scream and say, no, I'm fine, or you're stealing my money, that kind of thing. But if this panel who I've chosen while I was competent says I no longer have my legal capacity, then we don't have to go to court. We don't have to do guardianship. We don't have to rely on power of attorney. But instead, my trust agreement says if I'm determined to be disabled, my disability trustees, my wife initially, or my wife and sister-in-law, they can step in and take over my affairs without me having to do anything. All we do in that case, we prepare what are called certificates of disability signed by the panel members. Then we do what's called an affidavit of successor trusteeship. So the next level trustees will step in and they'll take over seamlessly, be able to handle all my financial affairs without me having to get involved. And then when I pass away, if I were married, there would be other trust structures here, but we simplify it. So let's assume I'm not married. Upon my death, 50% goes to my daughter, Emily, 50% goes to my son, Aaron. But you notice we have more boxes here. So this signifies in our practice that we're leaving it in a trust form for them rather than outright distribution. And we'll get to that very soon about why that's a much better plan than outright distributions. And we're going to get to that right now.
So here we have what we're calling the protection continuum. And I'm sure you have already put together that each trust that we are showing you when we're discussing today, it has a particular function. It serves a certain purpose. And whether that trust is something that is giving you control and helps you to avoid a guardianship proceeding and probate, or maybe it's for Medicaid protection. Ultimately, when these assets are passing to the next level of beneficiaries, we're using trusts there too. And it's more for different purposes than maybe just your Medicaid protection, right? So here we show this protection continuum because we want you to understand that these subtrusts that you're creating, these testamentary trusts, have some value. They have some protective mechanisms. On the left side of the screen, you're going to see least protection, the side of the continuum with the least amount of protection. And there's different ways that these distributions can be made, but they're all considered outright distributions. And what you'll see there is that if it's in a lump sum distribution, meaning after I pass away, the assets are divided, let's say 50-50, child 1 and child 2, they receive those assets in a one-time distribution directly to their names, checks made out to them as individuals. And what do they do with that check? They take it, they deposit it into their own bank account, and then if they ever got sued, if they ever got divorced, if they ever became ill, those assets are subject to those creditors, to that divorcing spouse, just like their own assets are already. So that's the lump sum distribution. It's an outright distribution at one time, and there's no protection once the distribution is made to the beneficiary. There are also distributions that can be made in phases and stages. So let's say I'm concerned that the assets would pay out, but my beneficiaries are a little bit younger. So I don't think that they're very responsible. So at the time I pass away, if my beneficiaries are around or achieve age 25, maybe I allow them 1/3 of their share, their distributive share. And the 1/3 will come out, and I know they're kind of young, so they might squander it, they might buy something silly, but that's okay because they still have 2/3 reserved for them, right? Then I say maybe at 30, they get their next third, and at 35, they receive the last final distribution. The problem with it is that each of those distributions, again, is coming outright. So when they get that 1/3, they can put it in their own bank account, and it is again subject to any creditors, divorcing spouses, or other liabilities they may incur. You can also say, instead of ages, you can say at the time they graduate college, they get a portion. At the time they get married, they get another portion. At the time they buy their first home, they get another portion. But again, anything that forces the assets outright to the beneficiary, once they come out, they are no longer protected. So when we're doing our planning, we like to actually be on the right side of the continuum where you're getting most protection. And you're going to see different kinds of testamentary trusts listed on this right side. I will say that the revocable trust or irrevocable trust, whatever document you're putting in place, it's completely customizable. The parts that are during your lifetime, the parts upon your disability, and then these parts here after you pass away. They're all customized according to your objectives and maybe your beneficiaries. So we're going to look at a few samples here, but again, these can be tweaked to your liking. The one that's called the Liberal Lifetime Protective Trust. This can be designed for a beneficiary who you trust. You think that chances are if they received an inheritance, they wouldn't squander it or purchase anything silly. They generally make good financial decisions, and there are no major problems in their life. So what you do is you allow for their distribution to be made in a liberal lifetime protective trust where the beneficiary themselves is their own trustee. And what that means is that because they are their own trustee, they don't have to ask anyone else for permission or for distributions out of their trust. They can make distributions for anything that they want or they need. But a counseling discussion would happen with that beneficiary to explain to them that while they don't need to use these funds, they probably would want to leave the funds in that protective trust that they manage and control, because the protective trust here actually protects these assets that they're inheriting from any creditors that may end up suing them or maybe not, any divorcing spouses. If they were ever married, got divorced, the ex-spouse can't take any portion of their lifetime protective trust. If they ever became ill or down the road they needed long-term care, these assets here would not be subject to any kind of Medicaid spend down or anything of that nature. And to the degree that you want, you can also build in some bloodline protection. So if you wanted to ensure that these assets pass to your beneficiary's descendants when your beneficiary passes away, you can do that. You can say where these assets will go after your beneficiary passes, a little bit of controlling from the grave there. So again, the liberal trust, there's no restriction on the access that that beneficiary has to the assets. They're the trustee, so they manage and control the assets within the trust and when distributions are made. Let's say you have a beneficiary who has proven to have a limited financial knowledge and skills, okay? So maybe they make some poor financial decisions, or maybe they have an addiction, or they're just a bleeding heart, and you know that when they receive their inheritance, they would probably donate to every animal shelter in Orange County. For them, you may consider something more like a conservative lifetime trust. In the conservative trust, that beneficiary is not going to serve as their own trustee, and that's for whatever reason. Maybe they haven't shown anything to you during your lifetime that makes you think they wouldn't be a great trustee, but you just don't want to give them that amount of control. It can be for any reason, but you choose someone else to serve as their trustee. So that way that beneficiary doesn't have the final say over the distributions, someone else does. Can be a close family friend, or it could be a corporate fiduciary if you have an institution that you really like. Otherwise, the terms of the trust will dictate when and how those distributions should be made. So if you think maybe you want your beneficiary to receive $5,000 out of the trust every year, only by asking. They don't have to prove themselves to the trustee. They simply ask and they will receive up to $5,000. That's fine. You can customize that into your conservative trust. And then anything beyond $5,000, it's up to the trustee's discretion. So you really get to play with this language a little bit to suit your particular beneficiary's needs or whatever maybe their nature is, their behaviors. Then we have the special needs trust. This is also known as a supplemental needs trust. This is for a beneficiary who is qualifying for government benefits, maybe based on a disability. And so they cannot have assets come directly to them in any other form because it risks disqualifying them for the government benefits that they are otherwise qualified for. So you can set up a supplemental needs for a beneficiary who's receiving government benefits from the start. So if you know your beneficiary would need the supplemental needs trust, you can put this trust structure in place right away. We also like to draft our documents, though, to have the supplemental needs trust available for any beneficiary who receives in any kind of trust if they become supplemental needs later on. So if they need to qualify for benefits later on. So for instance, if you had set up a liberal lifetime trust for a beneficiary, and long after you passed away, that beneficiary gets a little bit older, and now they need to qualify for some government benefits, their liberal lifetime trust can convert to a supplemental needs trust. And what it allows them to do is still have that inheritance without disqualifying them for their government benefits that they are otherwise qualified for. The supplemental needs trust cannot permit the beneficiary to serve as their own trustee. Unfortunately, that's just the law, the way it is right now. But you would choose who the trustee should be for that supplemental needs trust. So again, someone that you trust, could be a close friend or family member, could be a corporate fiduciary. So the conservative trust and this supplemental needs trust, someone else is going to serve as the trustee. The liberal lifetime trust, the beneficiary themselves can serve as the trustee. But all of these trusts are protected for the purposes of that beneficiary from their own creditors, if they ever encounter a creditor issue, from divorcing spouses, from any kind of illness or supplemental needs, disability, and again, to the degree that you want for bloodline protection, so that this way you can ensure where those assets go when even your beneficiary passes away. So we like this a lot better than the outright distributions because it comes with all of these protections and there's essentially no downside. There's no restrictions unless you want to create restrictions for your beneficiary. So this, in our opinion, is the much better way to go.
Without doubt. We only want to live on the right side of the ledger, because even if you are essentially giving your children an outright distribution, which is what a liberal lifetime trust would be, should they become disabled later on or have some creditor issue, they have protection. Over here, once the money is out, it's out. There's no protection. So there's no reason, unless you're talking $5,000 or something like that, to ever be on the left side of the screen. So one asset we haven't touched on in any great depth is retirement accounts. And for some people, many of our clients, this is the most significant asset people have, are their IRAs and 401ks. Unfortunately, under the current law, you cannot retitle a retirement account to a trust with the owner to be the trust. However, that doesn't mean that a trust cannot be the beneficiary. And where that became even more evidently important was as a result of a Supreme Court case from now 6 years ago, where the court ruled unanimously in the case of Clark versus Ramaker that inherited IRAs are not protected from the reach of the beneficiary's creditors. This would not apply when the spouse is a beneficiary, because the spouse can roll over an IRA and make it their own IRA. A child or other non-spousal beneficiary does not have that ability, and therefore the court ruled it is not a protected asset as a retirement account once it is passed to a non-spouse beneficiary. In the Clark case specifically, Mrs. Clark had inherited her mother's IRA, I think it was with Merrill Lynch, something like $350,000. A few years later, she had some financial setbacks, whether business failure, divorce, or all of the above, and filed for bankruptcy, not counting, because without her IRA, she really had nothing left. Well, she went to file for bankruptcy. The bankruptcy trustee, who gets paid based on what he or she collects, said, oh, good, I got this $350,000 IRA. I'm going to take that and give it to all your creditors. Her attorney, Mrs. Clark's attorney, said, no, it's an exempt asset under the law. The case worked its way all the way up to the U.S. Supreme Court, and the court ruled 9-0. No, Mrs. Clark, unfortunately, because you were not the original owner nor the spouse of the owner, and since you have to take distributions every year, even though you're not, 72 or 70 and a half, which was in place at that time, you still, these assets are fully available to your creditors. They get it all, you get nothing. So she ended up with losing the entire $350,000 IRA. So with that in mind, we are using frequently a retirement plan trust to serve as a beneficiary for non-spouse, or to serve as the recipient of IRAs going to non-spouse beneficiaries. So the next slide, we have a diagram of what this sort of looks like. So we have a guy named Archie who has $1 million IRA here. His primary beneficiary is his wife, Olivia. And if she survives Archie, she can take that IRA and whatever's left of it and roll it over into her name. Archie, once he reaches, under the new law, 72, has to take distributions over his remaining life expectancy. But upon his death, there's a fair amount left. Olivia can take it. Now, if she dies first, ordinarily, the IRA would go to their 3 sons, Cooper, Peyton, and Eli. But because Archie's attorney was a smart guy and realized that their Clark case could expose those assets to the creditors of any of the 3 of them, he set up a standalone IRA trust for Archie to serve as the contingent beneficiary beyond Olivia of the IRA. So upon both of their deaths, the IRA would be payable 1/3 to Cooper's trust, 1/3 to Peyton's trust, and 1/3 to Eli's trust. And these trusts down here can all be structured either as your liberal lifetime trust, which most likely would be the case. They can be structured as conservative trusts, even supplemental needs trusts. Under the new law, meaning as of January 1st, you may have heard of something called the Secure Act. The Secure Act now has done away, in the vast majority of cases, with a few exceptions, the rule that previously allowed non-spousal beneficiaries to withdraw an IRA payable to them over the course of their remaining lifetime. So a 40-year-old could stretch that out over many, many years. Now, no matter what the age of the remaining beneficiary, with a few exceptions, there's a 10-year payout rule. So under that rule, the Cooper share would all have to be paid out to his trust within 10 years, Peyton's within 10 years, and Eli's within 10 years. But once it's paid to the trust, the assets can sit there in this protective trust, sheltered from divorces, creditors, catastrophic health events, and all the things that we've talked about. Now, of course, if each son here is their own trustee, they can decide when and how to withdraw assets from the trust. So if they don't face any of those particular risks that we were just talking about, they can fairly comfortably take out those distributions in the year that they're paid out, or a portion of them. So it's all about control and flexibility to the beneficiaries, and ultimately protecting those assets from all the bad things that can happen in life. So that's the retirement trust that we are using quite regularly. So let's talk about taxes. Do I need to worry about taxes? And what's the real story with the estate, gift, and capital gains tax? I created a couple of polls today, and I'm going to share one with you now. So I'm going to launch this poll. So the question is, and you can all answer it, what percentage of estates will owe federal estate taxes in 2020? Or is it 20% of all estates, 30%, less than 1%, or 10%? So if you take a moment here and vote on this, check the box, and we'll be very curious at what people come up with. Okay, we've got 1/3 of the voters, all right. Got 4 out of 9 so far. Up to 5. We got every category has been answered so far. That's pretty cool. Okay. So a few other people either are thinking, don't want to participate, or asleep. One of the 3 could be any one of them. Okay, so of the people who voted so far, we have 1 person who says 20%. 2 out of our voters have said 30%. 1 intrepid soul said less than 1%, and the other person said 10%. Well, drum roll, please. The answer is less than 1%. So whoever answered that, you deserve a prize. If I had one, I would send it to you. Anyway, so people are very surprised by that. But once we get into the numbers here, I think you will be less surprised by that result. So let me shut that down here and close that. So moving ahead on our slide. So first we're going to talk about the gift tax. And the gift and estate tax are 2 interrelated taxes. The gift tax, there is what's known as the annual exclusion. And many people are familiar with this idea that every individual can give up to $15,000 a year to any other individual in any calendar year without paying gift tax. All right. So we have 9 participants on this webinar. If I went around to each one of you and gave you $15,000 a year and said, here you go, presumably you would thank me for that. And you would probably say something to the effect of, oh, thank you for that lovely gift. Well, in the Internal Revenue Code, anything up to $15,000 isn't defined as a gift at all, even though the average person, of course, would consider it a gift. The government doesn't want to be involved in having to worry about what they call de minimis gifting, and so they don't define anything under $15,000. It could be cash, it could be real estate, et cetera, et cetera. So what happens if you give more than $15,000 a year? Well, every person can give up to $11,580,000 throughout the course of their lifetime in total lifetime gifts, and that's in addition to the $15,000 per year per person. And this number has been and will continue to increase at least through January 1st of 2026, depending on what happens with the law at that point. So this number will be over, probably $11,700,000 next year. This is a federal gift tax rule. There is no New York State gift tax. There hasn't been for 20 years. But here's a very important caveat. If you give that $15,000 or something else up to that amount to all your family members each year because your accountant said, give this money, or your family lawyer said, give this away so that you can protect your assets if you need Medicaid, and then 3 years later you apply for Medicaid and you've made $180,000 of gifts to all your kids and grandkids, the Department of Social Services will say, all right, that's going to cause a penalty period of close to 2 years. And you say, hey, but those are permitted gifts under the law. Medicaid office will say, yeah, they're permitted under federal tax law. Has nothing to do with Medicaid. Medicaid can actually penalize for $1 gift, hypothetically, even though they wouldn't do that. So you have to be very careful, and any gifting for Medicaid eligibility purposes has to be done very strategically and purposefully. So let's just go back to the gift tax for a second. So going back to my example, if I gave all the 9 webinar attendees $15,000 a year, because Megan has been such a dutiful and important member of our firm, I say, okay, Megan, I'm going to give you a personal gift of $25,000 this year. Well, $15,000 of that gift to Megan would count towards the annual exclusion amount. What about the other $10,000? Do I have to pay a tax on it? Does Megan have to pay a tax on it? Does anyone pay a tax on it? The answer is almost certainly no. No one's going to pay tax. Because what happens then is, out of my $11,580,000 of lifetime gift exemption, I now just have to subtract 10,000. So I only, and I use that word very loosely, only have 11,570,000 of lifetime gift exemption left. So as you can see, other than very, very, very wealthy people, gift tax no longer is an important consideration in virtually anyone's planning situation. Taking it to the estate tax, well, we have that same number, 11,580,000 passes estate tax free. So that's why in our poll, the person who guessed right was the one who said less than 1%. It's, I think, like 0.7 or 0.6 of 1% of all people dying in 2020 will have a large enough estate where estate taxes will be a concern. For that very small percentage, the tax rate for the excess amount is about 40%. Now, importantly, the federal law is currently slated to terminate or sunset as of December 31st, 2025. And unless Congress passes new estate tax and gift tax legislation, we'll be basically cutting in half the federal estate tax exemption from, say, close to 12 million to now 5.6 million, but that will be increased for inflation. So given our budgetary deficit, the COVID relief that had to be paid out, for the first time, many practitioners are really believing we are going to come back to this number or something to it. But of course, that's all going to hinge upon who's in power at that time. We still got, 5 years till that becomes an issue. How about New York? How does that work for estate tax? We already talked about there's no separate gift tax in New York. Estate tax, this should be effective 1/1/20. That's an error, so you can correct it on your own copy if you print it out. The current decedent estate tax exemption in New York is $5,850,000 per individual. So it is roughly half of the federal exemption. So a higher percentage of decedents will pay a tax in 2020 than under federal law, but still not a lot of people. And each year, this number increases by a formula based on a multiple under the Consumer Price Index going back to 2010. So next year, it'll be probably in excess of $6 million, even though inflation is very low. So as you can see, I think estate taxes really affects a very, very small subset of the population. Back when I really began as an estate planning attorney in 1999, we had a much different situation. The federal and New York State estate tax exemption at that time was only $600,000. So even though that's 20 years ago or 21 years ago, 600,000 even in 1999, there were plenty of estates that exceeded that amount. And so probably 15 to 20% of all estates, if not more, were subject to estate tax at that time versus less than 1%. Now here's another very important tax that is much more relevant to the average person today. That is our capital gains tax. What's very important is that, well, let's sort of take a discussion of what capital gains tax is. It applies primarily to things like real estate and securities, appreciated stocks, things of that nature. So let's say you had a share of stock in ABC Corporation that you paid $10 a share for, and today it's worth $110. If you were the purchaser and decided to sell that stock, you would make a profit or a gain of $100 a share. Now, between federal and state, there's a capital gains tax. You will pay, let's assume, a third. So roughly $30 of gain per share you will pay as capital gains tax. Not a pleasant thing that most people are happy to do, but that's what our code does today. Fast forward, you have the stock at the time of your death, you still own it, and it's worth the same $110 a share. It passes to your children. Say you have one child, your son Johnny. Johnny now inherits it and decides to sell it for $110. He pays zero capital gains tax because of something called a step up in cost basis. Johnny's entitled to pay at the date of death value the stock you paid $10 for now gets stepped up to its fair market value as of the date of your death to $110. Johnny is the beneficiary of that because he gets to sell it at its stepped up cost basis of $110, pay zero tax. And I think the next slide talks about that. And the same thing happens with real estate. If you gave it to your kids outright, they take your carryover basis and they will pay a capital gains tax if they sell it. However, if they inherit it at your death, the gain on the house is wiped out in the same way that the gain on the stock that I described is wiped out. So anything you give during lifetime that has gain, your recipient, your donee of the gift, takes what is called a carryover basis. They get the same cost basis you did. You die, they get a step up in basis as long as the asset is part of your taxable estate. And with these large estate tax exemptions, 5.8 million in New York, 11.58 million for federal, we have a lot of leeway for the vast majority of estates that we deal with, and we don't have to worry about capital gains. So we much rather have those assets included in our estate. We're not worried about estate tax if we're not in the 1%, and the assets get a step up in cost basis. Our kids get to sell them if they want to, pay no tax. So they're not going to pay estate tax. They're not going to pay capital gains tax. Everyone wins except for the tax collector. So with that in mind, we've covered our sort of estate planning component by and large. We're going to shift into the Medicaid planning component. I did create another poll here, so let me see if I can find that here. Oh, here it is. So here's another poll before we get into the Medicaid. I'm just figuring it out. Simple one, true or false? A person who gives $100,000 to a child the year before going to a nursing home will be ineligible for Medicaid for 5 years. True or false? I'll launch this poll. I have to do that. Now you can answer it.
I didn't see it pop up. Should it come up for me?
Well, it probably should have. Yeah, I don't know why it didn't. I'll read the results. We've got 3 votes. Now we got 4. So up to 4. We got 5 votes. We'll see if anyone else pitches in this time, or if we're going to be stuck on our 5 votes. Oh, we got 6. We got a 6 vote this time. All right. So we got 6 out of 9 voting so far, and we'll wait another. I'll wait another few seconds and see if anyone else wants to pitch in. So far, out of the 6 voting, 5 has said true that there will be a period of ineligibility for 5 years, for 5 years, and 1 person, the contrarian, bucking the trend up. We got a 7th one, so we got 2 out of 7 who have now said it's false, 5 out of 7 who said it's true. Okay, so I am now we'll give the answer. So Megan, what is the answer to this question? Oh, you don't see it.
No, I don't see it. I'm going to say a person who gives, what was it, 100,000?
To a child the year before going to a nursing home would be ineligible for Medicaid for 5 years.
My answer is it depends. Is the child disabled, Rich?
Good point. See, Megan, being the skilled professional that she is, realizes there's actually nuances. I'm assuming that the child is not disabled. So I should have said to a non-exempt person, right? The real answer here, folks, with the caveat Megan threw in here, is it is false. A $100,000 gift will not cause a 5-year period of ineligibility. And that's, I'm not surprised that the most people said true. You shouldn't hang your head in shame or anything, because that's what most people would think. So we're going to now go into the reason why that is not the correct answer. So Megan, I'll let you, I'll share the results here. Okay. So we're going to move into our Medicaid planning component.
Yes.
So Megan, let's start here.
Yeah.
There we go.
And when we're talking about Medicaid, you guys probably are already well aware. What we're talking about is planning for the expense of long-term care. And that's going to include Maybe someone's health is declining, but they want to stay in their home. So they hire a service where an aide comes to the home for a few hours per day or per week. It can include assisted living facilities, someone who now needs to move to a facility, but they're still a little bit independent, right? And it can include nursing home facilities. So when we're talking about the cost associated with each of those different levels of care, it can be quite expensive. And we're going to see lots of numbers thrown around here today. But there are different ways that a person can pay for that long-term care. And the first and foremost is just pay for it out of pocket. Because it's expensive, if any person is spending a longer duration needing that care, they are probably going to burn through their assets relatively rapidly, which just means that they are preserving less to pass to the next generation. Another way to pay is through long-term care insurance policy. So some of you may have it, or it might be something that you are thinking, oh, I should look into that. That is where you pay for a policy that in the event you need long-term care, then the policy will pay for all or a portion, more than often it's a portion, of your long-term care needs, and that way you have to pay a little bit less. And then Medicaid. Medicaid is the last way that long-term care can be paid for, but in order for you to qualify for the government benefit, Medicaid, they want to see, Department of Social Services wants to see that you yourself cannot pay for your care. You don't have enough assets in your name. So it's really a resource-based benefit. Not everyone qualifies. So we're going to go through a lot of the eligibility requirements, who would qualify for Medicaid to pay for their care. And then we're going to go through some planning strategies for how you can actually get yourself to qualify even without on the surface meeting these eligibility requirements. So first, there is a limit on the resources or the assets that the applicant can have in their name. So the person who is needing Medicaid to pay for their long-term care can only have up to $15,750 worth of assets in their name. So that can be the value of their checking and savings, stocks, bonds. Dig out those bonds, guys. Those ones tend to be sticky. You find them, they were hidden somewhere. So stocks, bonds, cash value of life insurance, all of these things are going to be tallied up. And if they are valued over $15,750, then immediately you're not going to qualify for Medicaid to pay for your care. This is not going to include your primary residence. It's that number, the value of your house is not going to count towards this $15,750, but there are some nuances having to do with the primary residence. Limits on income. So as long as you're meeting the $15,750 or you're below that, you are going to be eligible for Medicaid, but Social Services also wants to take a look at your income, and they set a limit. And if you are above that limit, you would still qualify for Medicaid, but you'd have to pay your excess income over towards the cost of your care. And then Medicaid will pick up the remainder of the bill. So for what we're calling a non-institutionalized individual, so someone who is staying home and an aide is coming to the house to assist them, without really getting into the weeds of it, technically they can keep $875 per month. There is a $20 differential, so it ends up being about $895 per month of their income that they can keep. Anything above that $895 is technically supposed to get paid over towards the cost of their care. There is a tool that can be used for community Medicaid purposes. That's an aid in the home or assisted living. That's called a pooled trust. And by using a pooled trust, you can actually preserve even more of your income. So if you receive monthly more than the $895, but let's say you really need that extra income to take care of the different bills and things that you do have, you can set up a pooled trust. Your excess income will go into the pooled trust instead of going towards the cost of your care. And then the pooled trust can reimburse you for certain monthly expenses. So there is a way to sort of preserve a little bit more. But without doing the pooled trust, you get the $895 and your excess will get paid over towards the cost of your care. For an institutionalized individual, this is a person who is needing nursing home care. That person is only permitted to keep $50 per month of their income, plus they can keep an additional amount that would go towards the premiums for Medicare. But not much money. As you can see, $50 is not a whole lot to live on, but the idea being that with you being in the nursing home, you will not have as many expenses, and so you won't need to keep as much of your income for those items. Instead, your excess income above the $50 per month will get paid over to the nursing home, and then the rest of the nursing home bill will get paid by Medicaid. There are also some eligibility requirements if you are married and only one spouse ends up needing the long-term care. The spouse who doesn't need that care, we're going to call them the community spouse. And there is also a restriction on the value of their assets and the amount of income that they can keep. So the community spouse is technically only permitted to keep $128,640 of assets in their name, not including the primary residence. And they're only allowed to have $3,216 of income per month. Now, there's a little bit of a caveat with the community spouse having to do particularly with income, but it can apply for resources as well. So let's look at the income first. If the community spouse is only receiving $2,000 per month of income, and let's say the nursing home spouse is receiving $2,000 per month of income, the community spouse has not met that $3,216 threshold that they're technically permitted to earn. So what the community spouse can do is keep $1,216 of the nursing home spouse's income. So the community spouse is hanging on to that full $3,216 per month. And then the nursing home spouse, the excess income there is actually going to get paid over towards the nursing home. If the community spouse, however, is receiving, let's say their income monthly is $4,000 per month, they're above that $3,216. So they're not going to get to sweep in any of the nursing home spouse's income to keep or to use. But because they're over the $3,216, they can file something called a spousal refusal. And that's only really available to us here in New York. A couple of other states have something similar, but ours in New York is the best version of this that's available. I think Florida and maybe Connecticut has it too. But the spousal refusal is the community spouse's way of saying, I realize that I have more income than I'm technically permitted to have, but I do not want to contribute my excess income or resources even towards the nursing home spouse, towards my spouse's care. And they submit that spousal refusal, the idea being that Department of Social Services will say, okay, you can keep everything that you have. In most instances, when we're doing the filing, Social Services does let the community spouse keep the excess income and resources. In some other counties, Department of Social Services will request that even though the community spouse is keeping more than they're technically permitted, they'll still request some portion of the excess be contributed over to the nursing home spouse's care. So it depends really where you're located in the state, what kind of response that you'll get to this spousal refusal, but it's a great benefit that we have here in New York that no other state is really able to take advantage of the way we are. So I know New York is probably very bad for a lot of things like taxes, right? But for Medicaid purposes, we have this great tool still available to us, which is that spousal refusal.
And those two concepts are not unrelated, honestly. You know, if you're paying a fair amount of taxes, which we do, there should be benefits that flow to various people, good, bad, or otherwise. One thing about spousal refusal I'll add is that it is under annual attack when the budgetary process comes up. And April 1st, this year was no exception. They did make some changes to the community Medicaid rules, but spouse refusal was left untouched. We may not be as lucky next year.
Right. Okay, so now we're going to talk about the look back period or periods. We're going to talk about two of them here. And this is something that you're probably a little bit familiar with by now. Essentially, when someone is applying for Medicaid to pay for their care, particularly nursing home Medicaid right now, at the time they submit their application, Department of Social Services will also want to see 5 years worth of bank statements, asset statements for the applicant, and if they're married, for the spouse as well. What they're looking for in that last 5 years, that 5-year period, is to see if the applicant or their spouse has been giving away any money or assets in the last 5 years to non-exempt individuals. So things like transfers between spouses or transfers to a disabled child may be an exempt transfer, but otherwise transfers out to adult children or unexplained gifts to anyone else really, those will be transfers that Department of Social Services will flag. And what they'll do is they'll tally up all of the transfers that have been made in the last 5 years that were to non-exempt individuals or really can't be explained away. They'll consider those gifts for purposes of trying to qualify for Medicaid down the road. And they'll tally them all up, and then they will, with a formula, figure out a penalty period for a period of time that they would refuse to pay for the applicant's long-term care. So like I said, they're tallying up the total cost of the uncompensated, which are just gifts, transfers. And what they actually do is divide that total amount by the average monthly cost of nursing home care. And each region within the state has their own fixed monthly cost of nursing home care. So you get to see those regional rates here on this slide. Ours is the one in red called the Northern Metropolitan Region, and that they figure that amount to be $12,805 per month for nursing home care. So that is how they'll use that as the divisor. So they'll divide up the total amount of gifts made in the last 5 years by the 12,805, and that number will be the total number of months that they will, Department of Social Services will refuse to contribute towards the cost of the applicant's care. So now the applicant themselves has to scrounge up the money to pay for that penalty period or pay for their care throughout that duration of the penalty period. Now I know we jumped past it, but there is effective in October of this year as a result of the budget that Rich was just referencing from April, effective in October, there is a new penalty period that is also being applied for community Medicaid applicants. So that is a person who needs care in their own home, or they end up going to an assisted living facility. If that person is applying after October 1st of this year, they will be subject to a 30-month or 2.5-year penalty period, where at that point, along with their application, they'll have to submit 2.5 years worth of bank statements. Social Services will check for all of those same transfers. They'll tally them up, and then they will use the divisor to figure out how many months of care Social Services is going to refuse to pay for, and the applicant has to find the money to pay for that themselves. And the reason I'm saying they have to find the money is because at the time they're submitting their application, their assets, in order to be eligible, have to be at or below the $15,750. So if it is longer than, say, 1 month of care for nursing home care purposes, they don't have that money in their bank account anymore. They're at the $15,750. And so if they were giving gifts, which it's sounding like that's what happened because a penalty period is being imposed, they have to go back to maybe their adult children and ask for some of the funds back to get them through the penalty period. So that can be a really tricky situation. So if there is any kind of gifting happening and you end up needing long-term care, it could be really problematic, and you may have to go back through and retrieve some of the funds.
Yeah, so
go ahead.
Yeah, so following up on that, and this is going back to the poll question. So in my example, a $100,000 gift, if that's the only amount of gifts within that 5-year period that we're talking about, we're going to divide that by $12,805, which comes in at 7.8 months. So a $100,000 gift, assuming the person, after making that total gift, is at or below the $15,750 resource allowance, they're not going to be ineligible for 5 years, as the poll question was discussing, but rather 7.8 months. As Megan was saying, they only have $15,750 or less, so who's going to pay for that roughly 8-month period? Well, hopefully, it's probably going to be money coming back from the adult children. If they don't have it or spent it or gambled it away, then you can try to apply under a hardship rule or some other throw yourself at the mercy of the court kind of thing. Other than that, they're going to sue not only you for making the gift, but also the children who received it. We're talking about the nursing home, because that's the one who would get stuck with the bill if the gifts are not retrieved.
Right.
So it's not going to create a 5-year worth penalty. You'd have to make a gift of in excess of $500,000 in the 5-year period to reach that full 5 years. More than that, it'd be about $600,000 based on the math. So that's why that question, it tricks up a lot of people. They always hear about the 5-year look back, 5 years, and they think you give any money during that 5 years, you're going to be ineligible for 5 years. As you can see, that is not really the case in virtually any circumstance.
Right.
So let me get my little thingy stuck here. There we are.
So I think we talked, yes, here. So now we're going to talk about some proactive planning. And before we really dive into the proactive planning, we highly recommend that before you could anticipate needing the long-term care, you do this proactive planning. But if you are closer to needing long-term care than, say, the 5-year period or the 2.5-year period for community Medicaid, or someone who is needing long-term care relatively soon, we don't get into it here today, but there is a lot of planning strategies that can be implemented to still preserve assets, even if you didn't get around to the proactive planning. We can't make guarantees, and it definitely will not preserve as much as proactive planning would, but all is not lost. If you didn't know to do proactive planning years ago and now you're needing care, strategies can still be implemented to actually preserve a good chunk of the assets as well. But
Right.
Here today, we're going to talk about the proactive part of this, because this
Right,
is
so
what we want people to do.
Right. So as Megan was saying, we do have a very robust crisis Medicaid planning practice in our office, and inevitably 7 out of 10 people don't do proactive planning. They get stuck with crisis planning. So what we're talking about is now the 3 out of 10, hopefully the people on this webinar, who are going to be more proactive and do proactive planning for the right reasons.
Right. And this proactive planning really is involving that irrevocable trust that we started talking about earlier in the presentation. So the idea being that you would create this irrevocable trust with the idea that you're going to be protecting and preserving your assets in case you ever need long-term care, and setting up and funding that irrevocable trust today will start the clock for that 5-year look back, or 30 months for the community Medicaid. So it's important, though, that we say funding the trust, because we talked about title and how title of your assets really must match your estate plan. The same is true here. It's vitally important that not only are you setting up the trust, but the trust is being funded with your assets that you're intending to protect. And, your attorney, we work with you to make sure that those things get funded. But that's the important thing, is that the assets in the plan have to connect with one another. Once those assets get funded, they'll be in the trust for the duration of your life. But once they're in there and they make it past 2.5 years in the trust for community Medicaid, or make it past 5 years in the trust for nursing home Medicaid, they are going to be considered protected assets. So when you submit your application, because you may need long-term care in the future, you submit your application for Medicaid, you're going to let social services know that this exists, but you've transferred them to the trust before the look back period. And so those assets will not count towards your 15,750. It's only assets outside of the trust that will count towards the 15,750 eligibility threshold. So a Medicaid irrevocable trust cannot, this is just the terms of the trust, cannot provide the trust maker access to principal, but can permit access to income. So what we're saying is that the trust maker, when they set it up, they fund this trust with assets, and the trust by its terms say once those assets go in the trust maker, you, the grantor, cannot access principal of those assets. And that's kind of the trade-off for some of the protection. And there is a caveat to this that we're going to come around to in just a moment. But if those assets within the trust are generating any kind of income or interest, you are still permitted to access that income that's being generated. So if it's an investment account and the market's doing nicely and it generates some interest, you can withdraw the interest. You just have to promise to leave the principal alone. And as a trade-off for that promise, the principal amount within the trust will be protected once it's past that look back period. And again, we're going to come back to that. Using this irrevocable trust is almost always a better choice than outright gifts. And this is really for two primary reasons. The first is that you are the trust maker of this trust, so you are retaining control over the assets as if they're in your own name. Granted, you're giving up technical access to the principal, but you still control how they're invested. If you wanted to sell real property from within the trust, you control that. You're the trustee. So that is different, because if you were to give your assets maybe to your adult children, even if you did it 5 years in advance of needing nursing home care, once it's in your children's hands, they can technically do whatever they want with it. And while you would hope that they would listen to you, they may not. There's no guarantees. So they really could do whatever they wanted with those assets. And it also subjects those assets to the liability of the children. So if they got divorced or they were sued, we could have a real problem on our hands. The other thing is, I want you to remember the capital gains implications here. So when you give your assets, any kind of appreciated assets, to your children, they're getting a carryover basis. So if they were to sell those assets down the road and there was a gain, they're going to pay tax on the full gain, even that gain during your lifetime. Where instead, if you put the assets into a trust and the children inherit the assets through the trust, they get a step up in cost basis. So we get to mitigate some of the capital gains tax. So those are the two primary reasons that the trust is going to be a better tool than outright gifting. And so we have a diagram of an irrevocable trust here. We got a little more crafty. Instead of just those two-dimensional boxes, we're using a cylinder for this one. And you're going to see that you're going to be the trust maker. And if you're married, you can have two trust makers. You can have yourself and your spouse set this one trust up for the two of you. You're going to fund certain assets into the trust, and that is really going to be part of a counseling discussion to figure out which assets should go into the trust and which should stay out. Because remember, technically, you're not going to want to access the principal of these assets once they're in the trust, but we don't want to leave you truly destitute. We're going to leave a few things out so that you can continue to pay your bills and enjoy principal somewhere. The transfers to the trust are subject to the 30-month or the 5-year look back for purposes of Medicaid. So if you transfer the assets to the trust and then immediately need care thereafter, chances are we're going to say we need to back out of this trust and do something a little different. This isn't going to be the best strategy for you, because those transfers would incur a penalty period. But if you transfer the assets to the trust and you make it past the penalty period, the 30-month or the 5-year, then these assets in here are protected. As I mentioned, you're going to be your own trustee, and if you're married, very likely you'll have your spouse on there as your co-trustee to serve with you, especially if this is a joint trust. Sometimes people get a little bit questionable about whether or not they can truly serve as a trustee. We like for our clients, our trust makers, to serve as their own trustees unless there's a good reason that they shouldn't. Maybe their health is declining rapidly and they're really not suitable to serve as a trustee, but otherwise you're going to be your own trustee. And what that allows you to do is really manage the assets that are inside of the trust. So like I said, if we put an investment account in here and you decide that you don't really like the brokerage firm that you're working with and you want to move to a new one, you can do that all within the trust as the trustee. You can open and close accounts, move assets within the trust as long as it's all titled in the name of the trust. You can even sell your real property. Oftentimes your primary residence is a good asset to go ahead and put into the trust because it's a lump sum of equity, and people are very seldom selling their primary residence and then taking a nice big round the world trip with the proceeds. So we say primary residence can typically go in, but if you wanted to sell that primary residence, maybe you want to downsize or you just want to move out of state, you absolutely can do that. So you maintain or you retain the control over the assets. Even though they're not in your name anymore, they're in your trust and you're the trustee. You'll also get to designate who your successors are. So if you've lost capacity, you already have a series of successor trustees. And maybe you put the trust together today, you've chosen your successors, but down the road, you're thinking, you know what, that person wasn't such a great choice. I'd really like to swap them out. Certain provisions of this trust are amendable. You can change who your trustees are. You can also change who your beneficiaries are. And we're going to talk about that in a moment. Now, coming back to the principal, like I said, you are not permitted to access the principal under the terms of the trust. You only retain access to the income generated by those trust assets. But you are going to designate a certain group of beneficiaries who are permitted to receive principal out of the trust. And you being the trustee, you control those distributions of principal out of the trust. Oftentimes, you're going to choose some trusted people, like your adult children, or maybe we're using the phrase descendants, which could include grandchildren and any other people in your bloodline. And these are people who you may distribute principal out to. And that can be nice in case you want to make a small gift or you want to help someone out. But it can be really nice if down the road you end up realizing you need a little bit of the principal out of the trust. We try to plan very strategically so you never need to use this mechanism, but it is here as a safety valve if you ever need it. You as trustee can distribute principal out of your trust to your other designated beneficiaries. And it can be just to one of those people who are named. It doesn't have to be all of them. Let's say you need $10,000 out of your trust. You as trustee can distribute $10,000, or maybe you make it $10,100 out to your principal beneficiary, who's your adult son, John. Okay, $10,100 from the trust to John, and he says, thanks very much, deposits that amount in his bank account, but you kind of have a little chat with him saying, you know, John, I really need this $10,000, so you might feel generous in a month or so and give me $10,000. And you can hang on to the extra $100 for being a good sport about it. And in a month, John can then write a check from his bank account back to you so that you have access to that $10,000 and you can use it on whatever items you needed. Let's say John doesn't play ball. A month goes by and you haven't heard from John. You call the house and his voicemail says, I'm on vacation. I'm taking a cruise around the world. Ignore coronavirus for this example. And now you're saying, oh boy, what did he do with my $10,000? Well, you also retain something called a limited power of appointment, where you can change who your lifetime beneficiaries are. So you nix John as being one of these people who can receive your principal. And you can also nix him if he's your after death beneficiary as well. You can say, oh boy, he took my $10,000 and ran with it. I'm going to cut him out of my estate plan. Or I'm going to reduce his share by the $10,000 that he took from me and didn't play ball. So you do have some flexibility here, and that is a kind of a safety switch in case someone isn't cooperating with you. But very likely you're choosing people you trust and you're not going to have to worry about that all too much. So now those are your lifetime provisions. The idea being you're going to fund this trust and it's going to protect your assets. Like I said, while you're alive, if you want to sell your house, you absolutely can. There is a capital gains exemption that you can get for your primary residence when you sell it. You retain that capital gains exemption, so you still get that exemption. You also retain all of your property tax exemptions. So if you're getting the STAR, Enhanced STAR, or Veterans exemptions, then you still get those, even though the house is being transferred into the trust. You don't lose that. The trust also, in addition to having all these great protective benefits, has the after death dispositive provisions. So it will say after you've passed away or after the death of the second of you or your spouse, your assets will go to your children in this example, 50-50 split, or however you divide it up, into those protective trusts that we talked about on the continuum. So you see the cylinders there. The assets pass to the kids in the trusts that you've designated. Maybe child one got the liberal lifetime protective trust and child two had the supplemental needs trust because that's appropriate for their situation. Either way, the assets go in trust, and because they are inheriting the assets, they're getting the step up in cost basis. So when they go to liquidate them, they are going to be able to mitigate some of the capital gains tax implications that are there. So that is your irrevocable trust in a nutshell. You really are customizing all of the terms, and it's like the Swiss Army knife of trusts because it has a lot of lifetime value, all of the protection, and then it also has your after death dispositive provisions. So it kind of does a little bit of everything.
Yep, it's really become the go-to vehicle that we use in our practice far more than anything else because it fits the current circumstances. Well, less than 1% of our population has to concern themselves with estate taxes. Probably 95% of our population has to worry about possible long-term care diminution of their estate, and that's what this prevents.
Right.
So now we're going to shift to our last piece of the conversation, which is how do we do a plan and our process for doing estate planning, and we're going to talk about the importance of plan maintenance as well. So we've developed over the last number of years a program called the Legacy Assurance Program, whose name is describing what we're trying to do. Assure your legacy is going to work better than Esther Jones's legacy worked. First of all, according to a survey taken last year by caring.com, 57% of American families haven't done any planning at all. And that could include everything from totally impoverished people to multi-millionaires who have done no planning. It runs the gamut of the spectrum. For those people who have done planning, there really are two types of planning structures. There's what we call word processing planning or counseling and design. Word processing is basically your online planning platforms, your standard general practitioner who does pretty much every will they do is the same, just changing the Jones name to the Smith's name. Not a lot of counseling, no real counseling, no advice, and no coordination of the planning between assets, funding, and objectives. Versus counseling and design, which is exactly that, literally understanding the family dynamics that are faced in this case, coming up with various solutions, and designing and implementing the estate plan. So why is updating a very important part of the entire success or failure of an estate plan? Well, there are three fundamental changes, we call them the 3 L's, that affect every estate plan. Changes in the client's life circumstance. So like Esther Jones, when her husband died, that was a big estate, life event, her stroke. All those things are going to be relevant in her planning needs. Changes in the law. We talked about the new Secure Act that went into effect January 1st. We talked about the new Medicaid laws. Every year there are some new legal changes, some more dramatic than others. 2020 happens to be dramatic across the board on so many levels. And lastly, changes in your lawyer's knowledge and experience. One of the benefits that Megan and I get to take advantage of by focusing and concentrating our practice area on this specific practice is we're going to stay ahead of the curve and have the time and the motivation to continue to learn new things, to be kept up to breast on the law so that all our clients can take advantage of it. But if we don't have a way to have existing clients get in front of us in a formal basis, those people will not get the benefit of our new knowledge, changes in the laws, and so on. Unfortunately, on average, people go almost 20 years before they between updates of their estate plan. And I see that all the time. Today I met with someone whose will was in 2005, so that's only 15 years ago. But inevitably what happens, people get their first, basic will done back, when they have their first child is usually the first big event. They're not wealthy people by and large at that time. What they're concerned about, who's going to be the guardian for the children if something happens to them. So that's when they get their first will done. It's pretty rudimentary. It's got those testamentary trusts, keep the money in trust till our kid's 21, and then they get it and can go crazy with it, right? And then they think they've gotten it done, and life happens, and they're out they're working and doing what they have to do to stay by and buying the groceries and all the stuff that life takes up on all of us. They don't think about their estate plan. Fast forward 20 years, they were 30 when they did their wills. Now they're 50. They get the AARP card in the mail, which I got a number of years ago. And they say, hey, maybe this is the time where they get their first issue of the AARP magazine. They talk about wills. Oh, yeah, we should look into that again. That's how it works. But a lot can happen in that 20-year span, right? The other important thing with the funding is that 90% of the time when people have either revocable or irrevocable trusts, those trust buckets or trust chest of drawers are not fully funded. And the problem with that is, as we saw, that if you don't have the funding or title of the documents match your estate plan, it's not going to work in the way that you hope it would. And even when people go to the trouble of getting a trust done, inevitably the attorneys typically are just doing the deed to the trust, and they give you a letter of instruction. You have to do this, this, and this to get your trust funded. The clients don't do it. It just sits there. They forget about it, and it goes unamended and unfunded. And of course, over the course of years, they're going to acquire new assets, open new accounts, and they're not thinking of their trust because they did that 15 years ago. It's not part of top of the mind. That's a problem we see all the time. We also don't want people to think to fall for what we call the magic book myth. Everyone in our firm who does work with us, who does a trust-based plan, will get a nice red book, and the book has instructions. The trust is a set of instructions as a contract. But when a client passes away, the trust doesn't magically spring arms or legs and a head and do things. People named within the instrument have to be appointed and to do those things, or have to be designated to do those things. And inevitably, there's some legal work that's involved to do all to set up those trusts for the benefit of the children, the protective trust that we talked about. It's not a hard thing to do, but does require someone who knows what they're doing. So there is going to be some legal work involved. So ultimately, the question is who takes responsibility for each of the three phases and its cost, and when does all this occur? Now, the question is, you could just do your will, die, and then let your kids worry about it, and you don't have to worry about the cost of any of those things, but ultimately they're going to bear the brunt of that. The better choice is you taking advantage and taking control over it during each phase so that it's made easier for your heirs and at less cost to them. So under our legacy assurance program, it's designed to address all three phases. First of all, we want our clients to work with us as counseling-oriented attorneys that we are. We're not going to do a cookie-cutter approach to anything. We're going to really go deep, take a deep dive into the clients, their backgrounds, their lives, their children, their other key family members, if there are any. And when we deal with the kids, get into a full explanation of who they are, what makes them tick, how they relate with each other, very importantly, because we have to help try to identify those conflict areas and make sure you're not picking someone to be your executor or trustee just because of the oldest child. We want you to pick the best person and help you identify that if it's not obvious. We also want to make sure that after that initial planning is fully done, it's not the end all and be all, because we want to make sure we get you back on a regular basis and participate in our maintenance program. So we offer a formal updating program that I'll get into a little bit more in a few minutes. Excuse me. And lastly, we want to assure you and your heirs a controlled and fully disclosed cost structure upon your death, so you're not going to be hit with some of the bad results that we'll discuss in our example. In a traditional probate structure, the fee range, whether it's billed hourly or percentage or flat fee, you're going to see typically ranges between 2 and 5%, following what is known as the reasonable compensation rule in New York. Under the legacy assurance program model, and that's for all costs, creation, updating, which there really isn't any, and settlement. Under the legacy assurance program model, our total cost, soup to nuts, for creation, updating, funding, and maintenance is never going to exceed between 1 and 1.5%, and we'll get into how that works. So first, we're going to look at our little teeter-totter following what we call the traditional model. This is your sort of standard word processing, Esther Jones kind of will plan. It didn't cost Esther a lot to work with Sally Smith because it took a few minutes to do, a few $100s. So the cost was low, but as we saw in Esther's case, the value was low too. It didn't work. And not because the will wasn't admitted to probate, because it didn't control the assets. It wasn't updated, right? So there was no funding in Esther's case, for example. And there was no maintenance. That's not part of the structure. So when Esther died and Sally got around to administer the estate, you're going to look at a fee between 2 and 5% because ultimately everyone was fighting with each other. Not a good result. If there are state taxes returns required, which is again not as common as it used to be, they're almost always going to be a separate charge because the attorneys doing the settlement don't have experience doing them. They have to farm them out to the accountants. Most accountants don't really know how to do them. They stumble through them and they're going to hit you up for $5,000 or something like that. And ultimately, what is the likelihood that your personal planning goals are addressed? Pretty small. Under the legacy assurance program model, we look at it in a much different way. Our fee is based on putting more of the value on the front end of the plan under the design and counseling elements. So our fee will be 0.5% of your taxable estate, which includes the value of all your assets, real estate, stocks, mutual funds, bonds, retirement accounts, cash value of any life insurance, annuities, etc. What the government would tax you on if you were to die that day. Our fee range for our foundational planning will be a minimum of $5,000, a maximum of $15,000. So someone with a $2 million estate, total soup to nuts, you're looking at a $10,000 planning fee. If you have a $5 million estate, you'll be capped at $15,000. In those cases, usually people are going to have either a revocable or more commonly just the Medicaid trust, but for larger estates especially, they may need a companion other trust, a revocable trust in that case, and then we do charge a flat fee of $1,500 for that extra trust. If your case calls for a standalone retirement trust, like in the Archie Manning case or example, that's a flat $2,500 fee for the standalone trust. And for married couples, these are times two. It's a single cost, whether you're a single person or a married couple, the fees are identical for the value. To get the assets properly owned in your estate plan, in your trust structure, we do have a separate funding charge, which is based on the number of funding actions we need to complete. And we charge, and we have for years, $65 per funding action. So if you have a deed, a bank account at Orange Bank and Trust, another one at Bank of America, you have an account with Schwab, and an IRA, that's 5 funding actions, 5 times 65, that's your math right there. And it averages, my average funding fee is probably between $400 and $600 per case, and that's a one-time fee. Then to maintain your plan, this is very important. After you get the planning done, we then have you participate, if you choose to, in the maintenance plan. And what that does is that every year thereafter, you'll get an update of your documents as circumstances require, either your own personal circumstances or because of changes in the law or something new we've learned that we want to incorporate in our planning. You don't have to know about it until we tell you about it. We teach you about it, but you can live your life and know that we have your back and we'll get your planning updated when it's necessary. So as far as the maintenance goes, we charge $450 this year. And next year, I'm sure will be the same. And just to give you some perspective, this is year 20 of the maintenance plan. Hard for me to believe, but that's the truth. I started in year 2000 when I was a little bit younger, and I charged $300. So the increase is always tied to inflation, and it's been pretty modest, over only $150 over the course of a 20-year span. So we're not doing a bait and switch on that. So what do you get for maintenance? Well, as I mentioned, you get an annual maintenance update of your documents, so long as you attend one of our group client update meetings. We have one, for example, on Thursday. We're doing those virtual now, as well as someday again in person. Excuse me. You come to the group meeting, again, whether it's in person or virtual, we give you all the hot new stuff that's up on, that's for discussion this year. We give you a little advanced planning conversation. At that meeting, you register for your update signing, which we've done some virtual, we're doing more in person now. And you'll come in, meet with either Megan or Linda, who's coming back with us shortly, who will really be taking over Megan's role in doing those annual maintenance signings, and get your documents updated that year. We send you a planning review worksheet before that, so you can indicate to us any particular individual changes that you have. We gave our kids, for example, $10,000 in our last trust version. We now want to give them $20,000 apiece, or grandkids, for example. We can make that change. You want to change your trustee, your successor trustees from your son Johnny to your daughter Linda. We make that change. And that all gets built in your documents. We also send you a funding review worksheet so that we can verify what our records reflect as being in your trust, so you can also verify in your own that in case you've acquired new assets, so we don't get into a situation where our funding is less than complete. One of the other really important things of maintenance is the ability to reach out to me, Megan, Linda, or any of our support staff about any of your questions regarding your estate planning, your documents, anytime during the year at no additional charge. That's part, for a phone call or an email. Just yesterday, I got a call from a client who I did a Medicaid trust for in 2018. He and his wife are thinking of selling. Their property taxes are too high. They want to move to Delaware. So I walked them through the process of how to do it, how we can assist them, and gave them peace of mind that they're on the right track. So that's really, really a very useful tool in our estimation. So because we got the plan really well designed, we've got it maintained and funded, we know we can settle the estate at a much lower cost than the 2 to 5% probate fee. So we cap our fee in our fee agreement with you at 1%, not to exceed 1%, and that includes the preparation of an estate tax return. And we do file estate tax returns in many estates, even if no estate tax is due, to preserve what's called the marital deduction, to preserve another concept known as portability. It's not hard to do, but it has to be done. And that's all part of the fee. So that's our structure. So let's talk a few minutes here about some more fee things to consider as we're about to wrap up. So here's what the New York law is about reasonable compensation in an estate matter. The court in this case, and this is black letter law for all New York courts, in determining a reasonable attorney's fee, the court should consider factors such as time and labor involved, the difficulty of the questions involved, the amount involved, so the size of the estate is a relevant factor, counsel's experience, ability, and reputation, and the customary fee charged for such services. So those are all the broad categories. What's not here, and also often will drive the fee that is awarded by the judge, is how much the attorney contributed to the judge's last re-election campaign. Not part of the case law, but that's always understood. There's something to that, right? So here's a slide that is very instructive. This was an estate accounting for an estate that I represented a beneficiary. I was not the attorney for the estate. So this was prepared by the attorney, a local attorney who represented the estate. So a couple of interesting things here to see. The total estate amount, is $867,000. You notice the estate expenses here. The attorney got a retainer upon being hired of $5,000. There's a probate filing fee because this estate was the highest level, so it was another $1,280 that went to the Orange County Surrogates Court. Then there was a funeral bill paid out by the executor. And then you notice the big ones here. The executor's commission was $30,015, and the attorney took an additional $25,015. So the attorney fee, and this is often the case, was equal to the executor's commission. So at the end of the day, this $867,000 estate, before any distributions were made to the beneficiaries, was knocked down to a little under $797,000. So, I'll just point out a couple of things here. I use these arrows. So ultimately, what we see here is that the estate value was reduced by 8% for total administration expenses. So we talk about a 1% fee cap on our end. You can see the sizable difference between this estate and what our kind of structure would charge. So now I like to sort of wrap up with our fee comparison because it's helpful for people to see how in the real world, in our planning, this all works. So this is a real client. Obviously, the name has been changed. She came to us in 2007 when she was 81. We completed her planning that year, and her assets consisted of her home was valued at about $300,000. She had about $750,000 in cash and liquid investments. She had a small IRA of $70,000, and she owned a real estate partnership interest of $500,000. So her total estate in 2007 was $1.6 million. She died 10 years later in October of 2017. Her assets and her home was actually less at that time because she came to us right with the height of the market at the time. Her cash had grown by a little under $300,000. Her IRA, even though she was taking distributions every year, she was participating in a good bull market, so she actually increased from 70 to 100, and her real estate partnership interest was valued at $681,000. So at the time of her death, she was a little under $2.1 million of total value. Under the traditional model, you could assume she got a basic will done had she done that, an Esther Jones with a will, power of attorney, healthcare proxy, and so on, $650. There was no funding or maintenance in that hypothetical, of course. In our planning, she paid on a $1.6 million estate, she paid $8,000 for the design counseling of a revocable trust, and she added a Medicaid asset protection trust. Plus, we actually set up a limited liability company for her for another $1,000 to own her interest in her limited partnership. The total funding cost she paid us was $750, and she was in our maintenance program for 9 years with a total fee of maintenance cost she paid us over that 9-year period of $3,875. So we assume then, though, upon her death, so just going back a slide briefly. So this one obviously looks a lot more costly than this, right? But let's look at what really happens. If the attorney, like in the last accounting I showed you, charged 2.5% of the total estate, her heirs would have paid a total fee of a little under $52,000 for probate. And it would take on average between 6 and 12 months, even without COVID-19, to get through the estate process. Here's what her kids paid us. I could have charged them based on my fee agreement with Rhoda $20,000. We actually charged less than half that, or $9,000, and we were fully done with all the administrative work, getting her kids' estate trusts, those liberal lifetime trusts she set up for them within 3 months without any court proceeding. And keep in mind, she died, she was 91, her kids were already in their 60s, so the fact that their assets were immediately protected, their inheritance was immediately protected, should either of them need long-term care. Comparing to apples, under the traditional model, Rhoda's family was looking at about a $52,000 total fee, and our structure, the total fee for everything was $24,125. So, less than half the cost for a far, far better result. So with that all in mind, how does the process with us work for those who are interested in taking the next steps? The next step would be to set up what we call the initial attorney interview. And on the evaluation form that we provided, and I'll show you a copy in a moment, you can indicate on that, if you send that in to us, if you would like to meet with either myself or Megan and have that initial meeting. No cost to you. We ordinarily charge $400 for an initial consultation. In this case, you would not be paying anything for that meeting. We would be sending to you in advance of that meeting an intake worksheet and other documentation so that we could understand your situation and give you some advice at that meeting. At that meeting, we talk about the fee structure and reiterate what we talked about today. And if you decide to go ahead, we would set up a design meeting, which typically takes 1 3-hour session, but could go into longer sessions. Remember, we're on a flat fee basis, so time is irrelevant in the planning structure. Once the plan is fully designed and fleshed out, we then do our delivery meeting. That's when we sit down with you, either in person or virtually, depending on the case circumstances at that time. And we actually have you review and sign all the documents with full explanation of what they are and how they work. And then you're on sort of cruise control. We'll do the funding meeting. We'll have Sarah, our funding coordinator, will sit with you at the end of the delivery meeting. So these are really the same meeting, just one goes after the other. And you will get all your documents funded. We also offer a family team meeting. We could do a virtual meeting like on Zoom with your kids and explain how the plan works with your financial advisor. And that's something we certainly offer. And then thereafter, you're really on cruise control. You participate in the maintenance program for as long as you live, hopefully it's many, many years. And by the time, hopefully I'm retired at that point, you can work with Megan and take care of it. So that means you've outlasted me, which is good. So that's our structure. I'm going to share with you, if you hold on a second, let me get this here, and I'm gonna stop sharing this screen and share my other screen. If I can find it here. Oh, here it is, the evaluation form. So everyone, I hope, would have gotten this by email, and you can fill it out. It's a fillable form on the, where are you? Yeah. So you'd fill out your personal information up here. If you want us to set up a meeting with you, we would do that on this level here, where it says, please contact me, so you can schedule a no cost, no obligation consultation with us. And then we'd ask you to fill this out. Of course, the sample form has all fives. We would only expect that. But of course, seriously, if you thought we didn't do as well in some areas, we do want to hear that as well. You can add comments to the form, provide any additional feedback, and recommend other people. So that's really about it. We hope this has been a good use of your time. We would love to meet with you either in person or now more likely virtually for a while. We have the technology to do everything remotely, and we certainly want to help you get your affairs in order as necessary. If you have further questions, I don't see anything in our chat or Q&A. We'd be more welcome to answer them for you offline. But other than that, we thank you very, very much for joining us today. This has been recorded so that if you want to hear it again or see it or share it with someone else in your family, let us know. And once we get it uploaded, we can send it over. So that is about all she wrote. Megan, anything else to add for us right now?
I don't think so. Thank you, everyone. I do see a quick question.
Go ahead.
Do we have an office in Poughkeepsie? Is that what that stands for?
Yes, we do not have an office in Poughkeepsie. We do have access to an office in Poughkeepsie. So we can, in the right, if the circumstances warrant, meet in that area at an accounting firm that we are able to use their space. So hopefully that answers your question. Without anything else out there, we again thank you all for participating. And oh wait, there's another one, it looks like. Great, thank you. All right, that's good. Thank you, Linda. Appreciate your comments. And we thanks everyone for participating today. And we look forward to hopefully meeting you in person, virtually or in the real flesh at some point. And without ado, we'll sign off. Have a good night to everybody. Thank you.